blow everybody out of here. Good afternoon. We have, if anyone is here for the Chick-fil-A variance, that has been withdrawn. So if you choose to leave, you may. We also ask that you put your phone on silent. If you need to take a phone call, you may go out in the hallway and then come back in. We have right now 5 board members here. It takes 4 board members to deny or approve a variance. To approve a variance. It takes 4. We were told he was coming. He may have gotten caught in traffic. And with that, I will take a motion to consider the August 4th meeting minutes. Do I have a second?
Second.
All those in favor, say aye. Aye. And that has been approved. And Mr. Bach, Andrew Bach, will you introduce the blackjack variance?
Sure, thank you. The first variance before you is a variance from Article 4, Section 4-73JII, relating to the maximum fence height in the front yard for the property addressed as 3701 Blackjack Road, which is located in the R1 Single Family Residential Zoning District and is within the Ladson Road Overlay District. These are pictures of the property as they were posted for tonight's meeting. And here's the subject property outlined in this teal color here. You can see the yellow is the R1 zoning, and it is on the corner of Blackjack Road and Spencer Woods Road. And here's a more zoomed out aerial image. You can see the house is oriented towards Blackjack Road with the neighboring property to the rear facing Spencer Woods, which is the cause for the variance. And here's the site plan that was submitted showing the proposed fence location. This would be a 6-foot fence highlighted in yellow here. The property owner, Alan Tang, is seeking a variance from Article 4, Section 4-73JII, relating to the maximum fence height in the front yard for the property addresses 3701 Blackjack Road. The property owner had a 6-foot tall fence installed through his side yards and alongside his rear lot lines, shown in yellow on the site plan. Per the diagram in Section 4-3JII, where a lot's rear yard abuts the front yard of an adjacent lot, the area of the lot forward of the adjacent lot's front building line is limited to 4 feet in height. The fence's location paralleling Spencer Woods Road right-of-way, but set back 10 feet due to the general utility easement, places it approximately 10 feet forward of the front of the house located to the south of the subject properties. The property owner is requesting a variance to allow the installed fence to remain as shown in yellow on the site plan. I was just going to go back quickly to kind of explain that because that's a lot. So the house to the south here, anything forward of that building line is required to be a maximum of 4 feet in height. So on this site plan, to this side and to the rear, anything where in front of this building line towards Spencer Woods would have to be 4 feet. Per section 7-7.3 of the city's zoning regulations, the board must make the following findings to grant a variance. Number 1, there are extraordinary and exceptional conditions pertaining to a particular piece of property. The application notes that section 4-73JII, which illustrates 2 properties where the corners of the adjacent houses align, is used when determining the areas in which a fence taller than 4 feet would be permitted. It is asserted that the alignment of the subject property with the adjacent lot to the south is not in the orientation shown in section 4-73JII, as the houses are offset by approximately 14 feet. This offset, it is stated, resulted in a disproportionate reduction of the subject property's rear yard, which may be fenced in by a 6-foot tall fence. Staff believes the offset between the building lines is an exceptional condition that merits consideration of relief. Excuse me. Number 2, the conditions do not generally apply to other property in the vicinity. The application states that while there are a handful of other properties where the rear yard of one house adjoins the front yard of the adjacent house, the condition is not common throughout Spencer Creek Woods neighborhood. Staff agrees that the offset house's condition does not generally apply to most other lots in the vicinity. Number 3, because of these conditions, the application of the ordinance to the particular piece or property would effectively prohibit or unreasonably restrict the utilization of the property. The application asserts that the restrictions on the placement of a 6-foot fence result in diminished functional use of the backyard, as well as compromising privacy and enjoyment of the space. Staff agrees that strict application of the 4-foot tall fence requirement to this lot would unreasonably restrict the property's use. Finally, number 4, the authorization of the variance will not be of substantial detriment to the adjacent property owner or to the public good, and the character of the district will not be harmed by the granting of the variance. The application states that the granting of the variance will not harm any adjacent properties, the public good, or the character of the area. It is also noted that the neighborhood's Architectural Control Committee reviewed and approved the plans prior to the installation of the fence. Staff agrees that the approval of the variance is unlikely to be detrimental. Given the house on the subject property's positioning relative to the house on the lot to the south, staff believes that relief is warranted and thus recommends approval of the requested variance to allow a 6-foot tall fence to remain as installed as shown on the applicant's site plan exhibit, provided that an after-the-fact permit is obtained. I'll also note that a copy of this report was emailed to the applicant on Thursday, August 28th.
Questions for the city? Mr. Kane? Yeah, Mr. Kane. Would you like to speak?
Okay, the motion on the floor is to approve the variance request. Mr. Calhoun? Yes. Mr. Classer? Yes. Mr. O'Callahan? Yes. Mr. Simmons?
Yes.
Ms. Morrow?
Yes. Yeah, the motion, as it's written in here, that you get the permit after the fact.
Okay.
Your variance has been approved, so. Next item on the agenda is, Andrew, will you introduce the Constitution appeal?
This is the Rivers Avenue appeal that was withdrawn. Okay. The next item before you is an appeal of the decision of a zoning official under Article 7, Section 7-6, relating to the decision regarding a short-term rental permit application for the property addressed as 2718 and a half Constitution Avenue, which is zoned R1 single family and is in Council District 5. Here you can see the property on Constitution Avenue, the intersection of Gary Drive, zoned R1, and here's an aerial image of that property in the surrounding neighborhood. The registered agent, Micah Van Strine, on behalf of the property owner, NVS Ventures LLC, is appealing a decision of a zoning official under Article 7, Section 7-76, relating to the decision regarding a short-term rental permit application. The appellant purchased the subject property in September of 2024 and received a short-term rental permit, hereforth STR, permit for one of the two dwelling units located on the subject property in December of 2024. On January 30th, 2025, the appellant submitted an STR permit application for the second dwelling on the property. The appellant requested a status on the application of the STR permit, the second STR permit, on June 12th, 2025, and was told that the application was on the waiting list for a permit in Council District 5 due to that district currently being over the 60 STR unit cap set by a recently adopted change to the STR regulations limiting each council district to 60 STR permits. The owner now appeals that decision and his application must remain on the waiting list. Per Section 7-7.3A1, the Zoning Board of Appeals has the power to hear and decide appeals where it is alleged there is an error in an order, requirement, decision, or determination made by an administrative official in the enforcement of the zoning ordinance. The appellant's submittal provides the basis on which he believes STR applications should be processed and the permit issued, despite the requirement of Section 4-21F4 that STR applications received for a council district which is over the 60 STR unit cap can be held until the number of STR permits in good standing in that particular council district has fallen below the maximum allowed. Now both sides will present their respective positions tonight, and the board may reverse, affirm the staff determination wholly or in part, or may modify the order, requirements, decision, or determination.
Do you have any questions for the staff, board members? I call on the appellant, Micah Van Strine, to make his presentation. Okay.
Good evening. My name is Micah Van Strine, and I'm here with my wife Alicia and my brother-in-law Paul, and we make up NVS Ventures, the owners of 2718 Constitution Avenue. Thank you for the opportunity to present our appeal. I want to begin by saying that I respect the city's efforts to manage short-term rentals responsibly. We're not here to challenge the overall goals of the ordinance. We are here because our specific situation deserves consideration based on the timing of our application, our communication with city staff, and the fairness of how the rules are being applied to us. We purchased the property in September of 2024, knowing it contained 2 dwelling units. In December, we obtained our short-term rental permit for the first unit. From the very beginning, our plan was to permit both units, and city staff was fully aware of that intent. On January 30th, 2025, we submitted our application for the second unit. That was nearly a full month before the city council adopted the ordinance creating the 60 permit cap per district. The staff report states that the moratorium triggered the Planning Commission meeting on January 13th means that our application was submitted too late. But it's important to note this. We applied before the law was passed, and we did so after direct conversations with city staff. Tanya McCargo, who oversees the short-term rental permitting, graciously contacted me and specifically encouraged me to submit before the cap went into effect. That demonstrates two things. First, that the city knew we were planning to permit both units, and second, that we relied on staff guidance in good faith when we submitted our application. This is not a case of us trying to sneak something in or take advantage of the process. We were in open communication the entire time. We acted promptly, transparently, and based on city advice. The intent of the cap is to prevent overconcentration of short-term rentals in the neighborhoods. In our case, both units are located on the same parcel, under the same ownership, and managed as one property. There's even dedicated parking for both units that is not visible from the street. Allowing the second unit does not increase the density in the neighborhood. It simply allows us to treat the two units consistently and fairly. If this appeal is denied, the second unit won't sit vacant. It will be used as a midterm or long-term rental. In other words, the house will still function as housing. Denial doesn't reduce rental activity. It only blocks us from using the property for its intended purpose as a short-term rental, which we had already communicated to the city well before the ordinance was adopted. I believe we fit in really well with the neighborhood so far. We get along with all our neighbors. My neighbor across the street, Cody, sent in a very nice email saying how well we've managed everything and how respectful we've been of the neighborhood. Our neighbor to the left, Bernard, really nice guy. I've been talking to him since day one. He'll come and cut the grass for us, take the trash out, do little odds and ends jobs for us. When we first got started, Preston, who lives down Constitution a little farther, got to talking to him. He owns a cleaning business, and we've been able to utilize his company to come in and do some cleaning for us. So I really feel like we're trying to do things the right way and be very respectful of the neighborhood. So in closing, I ask that you recognize that we purchased this property and invested in it under the old rules. We obtained one permit, and staff was fully aware of the intent to permit the second. We submitted our application in good faith before the ordinance was passed, relying on staff guidance. To deny this appeal would be to enforce a rule retroactively against someone who was already in the process, who was open with the city, and who has acted responsibly every step of the way. We respectfully request that our application be processed and that we be granted the ability to operate both units under the short-term rental framework. Thank you guys so much for your time. We really appreciate it.
Thank you. Any questions for Mr. Van Streen from the board? Okay, thank you. Do you have any questions? Do you have any witnesses to call or question? Ms. Anderson, to make the city's presentation, please.
Good afternoon. The board must decide on 3 issues this evening. The first being whether the applicant should have a blanket access to short-term rental permits because he has an STR for a dwelling unit housed on the same parcel of 2718 Constitution Avenue. 2, whether staff was correct in their interpretation of applying January 13th as the deadline date. And finally, whether the applicant's untimely application prevented their business from receiving protection while the text amendment change was underway. You will hear from Eileen Duffy, Planning and Zoning's Project Manager for the City of North Charleston. She will testify to the steps needed for businesses to secure a short-term rental permit, the date the text amendment was issued, the day it took effect, and the impact in which it had on both the rentals in process and the new applicants. We ask that you listen carefully and uphold the decision by the zoning official to place this short-term rental application on the wait list.
Any questions for the city attorney? Okay. Proceed. Excuse me? Oh, witnesses, I'm sorry.
I would call Eileen Duffy.
Thank you.
state your name for the record? Where do you work? And what is your title? How long have you worked with the city of North Charleston? Tell the board what your involvement is with short-term rentals. And can you tell the board how does an individual get a permit? And can you define what a dwelling unit is for the board? And if a business is already permitted for one dwelling unit, does this grant blanket access to additional permits? Can you tell the board how you're familiar with Mr. Van Stryden in the context of his STR application? Can you tell the board when the moratorium took effect? And can you confirm what day Mr. Van Stryden's application was submitted? Can you tell the board how the moratorium affected pending applications? And can you tell the board what district is 2718 and a half Constitution Avenue in? And is that district at capacity? What must Mr. Van Stryden do with his present application? further questions. Thank you.
Thank you. Mr. Van String, I'm saying your last name wrong. Okay, Van String, did you have, does the board have any questions for Eileen, the witness? No. Mr. Van String has any questions for the witness?
Excuse me, Madam Chair, you may want to ask him to form it in a question for the witness. He will have a chance if he wants to some. Any other questions for your witness?
Mr. Van String, to call you for summation? Thank you. Ms. Anderson, summation? Thank you. Call for a motion to reverse, affirm, or modify the staff decision.
Motion to affirm.
Discussion among board members.
I agree the timing is very unfortunate for you. Ultimately, we need to decide if staff have made a mistake here, and I think the timeline is the critical piece of paperwork that we're looking at. So I do not think that they have made a mistake here, given that the moratorium was in place when the application was submitted.
Any other comments? Andrew, would you do a roll call, please?
Yes, the motion is to affirm the staff decision that the STR would remain on the waiting list per section 421F4. Mr. Calhoun? Yes. Mr. Glasser? No. Mr. O'Callahan?
Yes.
Mr. Simmons? Yes. Ms. Morrow?
Yes.
The motion is upheld.
And with that, this meeting is adjourned.